Hello, everyone, and welcome to Internet Law Review. For today's story, we are doing some contract law analysis to answer the question, does President Trump owe Senator Warren $1 million? As you are probably aware, Senator Warren recently conducted a DNA test to determine whether or not she had Native American heritage, and there was some evidence to determine that one of her ancestors, somewhere between 6 and 10 generations ago, may have been a Native American to the United States. So we're going to look at this statement and analyze several different contract law questions that emerge from it. So first, we need to take a note of the location, Montana, because this will be decided under state law, and the contract was made, if at all, in Montana. And we need to look at some statements here. And he says, I promise you I'll do this. I will take, those little kits they sell on television. We will take that little kit, but we'll have to do it gently because we're in the Me Too generation, so I have to be very gentle. And we will be very gentle, take that kit, slowly toss it, hope it doesn't injure your arm, and we will say, I will give you $1 million to your favorite charity, paid for by Trump, if you take the test and it shows you're an Indian. So, several things of note are here. Issue number one, is this a serious offer? A contract has to be serious. If you're just being joking or just playing around and just being facetious, no contract. If you say, give me $1 billion for that apple, no one's going to take you seriously. And it's not intended to be taken seriously. So issue number one is this a serious offer? I would tend to say no. But the court would have to analyze that issue. Number two, assuming it is a serious offer, this is what's called a unilateral contract. What is a unilateral contract? Well, most contracts are bilateral. You have two known parties, and the parties are exchanging things with each other in a mutually agreeable way. But a unilateral offer is where one party is making an offer, often to a party unknown, and the only way to accept it is by performance. It's usually with respect to a specific task. So an easy example of this would be a sign you see on a lamppost that says, lost dog, $500 for return, gives a picture of the dog, perhaps a name and some contact information. I'm sure you've seen signs like this all the time. Well, that sign is what's considered a unilateral contract because it is an offer by one party that's setting out all the terms and it's setting out the conditions for success. You have to perform the contract. The $500 is for the lost dog. You cannot accept by agreement. You can only accept by performance. And so the way you accept the contract, and for that matter, complete the contract, is by delivering the dog to the person in question. So this is a unilateral contract because it is one party setting out all the terms. This case, the party is known, Elizabeth Warren, but Elizabeth Warren is not a participant in this exchange at all. She's not even here in the room. So this is just President Trump making a one-sided unilateral offer. Now, that's important because many states do not recognize unilateral contracts at all. Unilateral contracts are often very suspect and they're disfavored. The $500 for lost dog is pretty clean, but there are a lot of circumstances in which they're not particularly clean, and some states, as a result of that, have just made the policy decision we're not going to have unilateral contracts at all. So there are some states where the $500 lost dog, if you show up with a dog and they don't give you the money, you're just plumb out of luck. So question number one might be, does Montana have a law that prohibits unilateral contracts? Okay, another issue is, did she perform what she had to perform? Now, you might say, well, she took the DNA test, but let's look at the words very carefully and trying to determine whether or not she performed what she was asked to perform. And we say it like this, I promise you I'll do this. I will take one of those little kits they sell on television for $2. We will take that little kit. We will have to do it gently. We will gently take that kit, slowly toss it, hope it doesn't injure our arm, and we will say, statement. So the argument would be that she did not actually satisfy the condition of the unilateral contract because the unilateral contract didn't say take a test or any test. It said, I will take the test. We will take the test. We will gently take the test. So it's contemplating Trump, or who would be part of his associates as part of we, it's contemplating one of them doing the test themselves. So I think there's a very credible argument that she did not perform the condition of the contract because it was just a general DNA test from someone she picked. It was not someone that Trump or one of his associates picked. So she, I do not believe, satisfied the condition of the contract. There's also a second condition of the contract, and it's the shows you're an Indian line. It says, if you take the test and it shows you're an Indian. Question, did Elizabeth Warren show she's an Indian? The answer to that question is legally no. And the answer is legally no for a very specific reason. The term Indian is a protected legal term in the United States. For fairly obvious historical reasons, the United States has a somewhat troubled relationship with its Native American populations. And we have protected Indians, at least to some extent, by law. There's a whole Bureau of Indian Affairs in the United States federal government, and the various tribes of Native American heritage are granted sovereignty to conduct affairs in their own tribes, except where it's explicitly forbidden by federal law. So they can conduct their own affairs as though they're an independent country, at least somewhat. So to be an Indian is not to say that you have Native American heritage. And the Cherokee Nation themselves has come forward and said exactly this. Their Secretary of State of the Cherokee Nation came forward and said no DNA test is sufficient to show Indian membership, and he's completely right. Whether or not you're an Indian is to say whether or not you are a member of a recognized Indian tribe. Warren is not a member of Indian tribe. And for that matter, if you take the test and shows you're an Indian, I would argue actually establishes an impossible condition. It is not possible to take the test and show you're an Indian because there is no tribe in the United States who, because of a test, will declare you to be an Indian. There's no tribe who has that as a standard. You have to go through some sort of process to establish your Indian heritage, and there's no tribe that says a DNA test is sufficient. So there is the second condition, show you're an Indian. Not the same thing as saying show you're a Native American descendant. And the test cannot show that Warren is an Indian because Indian is a protected legal term. So there is a second condition in this thing. Not only do we have to administer the test, but the test has to show you're an Indian. And that second condition is actually impossible in this situation because it cannot be. Next issue is who has standing to bring a potential lawsuit. Now, normally the standing would be between the contracted party. So normally it would be Warren who would be able to have a legal claim. But here it says, we will give you $1 million to your favorite charity. So we will give you $1 million suggests Warren. But to your favorite charity suggests Senator Warren is a pass-through and has no benefit coming to her, and that the favorite charity is what's called a third-party beneficiary. So anytime you have a contract that has a third-party beneficiary, that would be where the third party is gaining something, then that's the situation. Now, it's actually very interesting here because there's arguably no consideration flowing to Warren. To have a contract, you have to have mutual consideration. Both sides have to be offering something. Warren is offering to do the DNA test. Well, and that itself is questionable as to whether or not it qualifies as consideration, but let's assume it does. The question is, what consideration is flowing to Warren? And the answer is, there doesn't seem to be any, because it's $1 million to your favorite charity. There's no benefit that's flowing to Warren, no legal benefit anyway. And so Warren doesn't appear to have any consideration flowing to her, and if she doesn't have any consideration flowing to her, there's no contract between him and her. And there's no contract between him and her, then the third-party beneficiary can't be a beneficiary to a contract that doesn't exist. So the fact that there's no consideration to her might throw the entire contract out. And even if we can get past that issue, because there's no consideration flowing to her, she has no legal injury. She's not been hurt by the fact that the $1 million hasn't come to her favorite charity, because it was never intended for her. So only the favorite charity would have an arguable claim to bring a claim, and they'd have to show that Warren was a valid participant in the contract in the first place. So, as you can see, there are multiple issues here. 1, was this a serious offer? 2, does Montana recognize a unilateral contract? 3, did she satisfy the condition that the test was to be administered by Trump or his associates as is suggested by the test? 4, did she satisfy the condition that it showed that she's an Indian? 5, was there consideration to Warren herself to make her a valid participant of a contract. 6, does Warren have standing to bring a lawsuit, or could only the charity bring a lawsuit? So the reason I'm doing this video is because it shows many different problems that exist in contracts. Even a statement this simple, we've got at least 6 independent legal issues that would be analyzed, and shows some of the dangers that might be available to contracts. So I think it shows how lawyers think about some of these issues, and shows how something that's apparently simple on its face, once you get into the details, is not very simple at all. So I don't know how a Montana court would rule on this. I don't even know if they have unilateral contracts at all. If they don't, then it's really easy to get rid of. And I don't know who could bring the lawsuit. But my overall suspicion, as you can tell from the tenor of my analysis, is that Trump would win the lawsuit, because it seems to me that the balance of legal issues are cutting in his favor. So whatever you think of the moral or ethics implications of this statement, I don't think if the offer was serious. If it was serious, I don't think she has standing. If she does have standing, I don't think she satisfied 2 of the conditions of this contract, and there are many other issues here that are defeating a legal claim to any sort of reparation. So I hope this was helpful, covering some basic contract law principles in the context of the Trump-Warren dispute. So for now, my friends, cheers. Later. Bye.